Hello, and welcome to the San Diego SHRM Quarterly Employment Law Update. This is your Quarter 4 update for 2016. I am Christine Mueller, the Vice President of Legislation for San Diego SHRM, and today I am pleased to highlight for you the remainder of this year's new employment laws in California, some changes to federal laws and regulations, and a couple of interesting cases. Every year, dozens of employment-related bills work their way through the California legislature. September 30th was the deadline for Governor Brown to sign or veto new California legislation. And this year, over 70 employment-related bills were signed, once again demonstrating that our legislature is very active on these issues. In previous editions of this update, we have briefed you on laws that were signed throughout the year. Let's begin today's update with some of the newest laws to be signed on September 30th, which could impact employers in California. We start with California's continued focus on pay equality. Last year, California enacted its own Equal Pay Act, which provides that employees of different genders cannot be paid differently for substantially similar work. A new law, SB 1063, expands these protections to wage differentials based on race and ethnicity. Now, in addition to gender differentials, employers cannot pay employees at wage rates less than the rates paid to employees of another race or ethnicity if those employees are performing substantially similar work. As we previously discussed with gender disparities, it can be difficult to determine what is considered substantially similar work under this law, and employers bear the burden to demonstrate that any wage disparity is based on a bona fide factor, such as a seniority system, a merit system, or another factor, like education or experience. California also enacted AB 1676, which states that an employee's prior salary history cannot, by itself, justify a disparity in compensation. This means, for example, that if an employer is paying a female less than a male for substantially similar work, the employer cannot rely solely on the fact that the female made less money at her prior job than her male counterpart did at his prior job. The reasoning behind this law is that employees may have experienced prior discriminatory pay practices due to gender, and that discrimination can follow them throughout their career. With this continued focus on pay equality, employers should make sure that any differences in compensation can be justified by legitimate factors. Employers should also note that pay equality issues are receiving a lot of attention in the federal context as well. For example, the proposed changes to the EEO-1 report have been approved. The new report will collect data regarding employee compensation and hours worked. Federal agencies intend to use this data to look at pay equality issues. So covered employers must begin using the expanded EEO-1 form for reporting calendar year 2017 data. Back to California law, there is a new requirement to provide notice to employees of their rights to take time off for sexual assault, domestic violence, and stalking. The Labor Code prohibits employers with more than 25 employees from discriminating or retaliating against employees who are victims of domestic violence, sexual assault, and stalking, and employees are permitted to take time off work to address these issues. AB 2337 was signed into law, which requires employers to provide written information regarding these rights to new employees at the time of hire. Most employers already have policies addressing these rights, but the new law requires the Labor Commissioner to develop and post a form that employers can provide to new hires. The form will be available by July 1, 2017, and employers do not need to provide any additional notice until the form is posted. Be sure to review upcoming issues of the Resource newsletter for updates regarding this form. Speaking of new hires, California employers already know that they cannot ask a job applicant or employee to disclose information about arrests or detentions. Employers can ask about certain convictions, but cannot use information about arrests as a factor in employment decisions. AB 1843 was signed into law and applies the same rules to juvenile-related arrests. Employers cannot require applicants to disclose information concerning an arrest, a detention, processing, diversion, supervision, adjudication, or court disposition that occurred under juvenile court law. There is a very narrow exception to this rule for health facility employers, but generally employers should stay away from questions about juvenile-related offenses, as well as any other arrests or detentions that did not result in conviction. California has also expanded immigration-related protections. SB 1001 provides that when employers go through the required steps to determine whether a new hire is authorized to work in the United States, it is unlawful for the employer to ask for more or different documentation than required under federal law. In other words, employers must follow the I-9 form precisely. In addition, employers must honor documents that appear to be genuine. Furthermore, for existing employees, employers cannot attempt to investigate or re-verify their authorization to work. Employers should also note that a new federal I-9 form has been published, and all employers will be required to use the new form no later than January 22, 2017. Next, under SB 1234, California will soon require employers to participate in a state-sponsored retirement program. All California employers with at least 5 employees will need to either offer their own retirement savings plan or enroll workers in the state plan, with a small percentage of each paycheck going towards the program unless workers opt out. It will take some time, likely until 2018, before the state plan can begin enrolling employees, and the program will phase in larger employers first. California also enacted a new law regarding venue provisions in employment agreements. Sometimes in an employment agreement, there will be a provision requiring that disputes be heard in a different state or under a different state's laws. Under SB 1241, such provisions are now unenforceable. If an employee primarily resides and works in California, he or she cannot be required to adjudicate a dispute outside California, and California law must apply. This new law applies to any contract entered into after January 1, 2017. And this new law will not apply if the employee is represented by legal counsel in negotiating the terms of the contract. Employers should check their employee agreements for compliance. Now let's move on to some health and safety related issues. Back in 2006, California adopted regulations regarding heat illness prevention for outdoor workers. For example, these include the requirements that outdoor employees be provided with shade and cool-down periods. SB 1167 will apply similar standards to indoor workers. We do not yet know what those standards will be, but by January 1, 2019, employers may need to expand heat protection practices to indoor places of employment. California also enacted a bathroom bill requiring all California businesses to designate their single-user bathrooms as accessible to all genders. Because this applies to all businesses in California, employers should check the signage on any restroom that is single occupancy. In other words, a separate room with a toilet and/or a urinal and a sink. Those restrooms cannot be designated as male only or female only and must be accessible by any gender. Moving on to federal rules and regulations, OSHA has published guidance regarding its new anti-retaliation provisions in its injury and illness tracking rule. These provisions are currently scheduled to go into effect December 1, 2016. OSHA is concerned about policies and procedures that discourage employees from reporting workplace injuries. While employers may discipline employees for violating safety rules, they cannot do so for simply reporting an injury. OSHA also clarifies that drug and alcohol testing of injured employees should only occur when there is a reasonable possibility that drug or alcohol use was a contributing factor to the injury. Blanket post-injury drug and alcohol tests would be considered improper. Employers should review their safety, drug testing, and incentive program policies to ensure that employees are not being discouraged from reporting injuries. Continuing with federal regulations, the new Department of Labor overtime rule, which was supposed to go into effect on December 1, 2016, has been blocked by a federal district court. The new rule would have more than doubled the minimum salary level for exempt employees to $47,476 per year, and it would have made more employees eligible to receive overtime pay. The district court ruled that the Department of Labor exceeded its authority in raising the salary threshold to such a high level. This means that employers do not need to go forward with plans to implement the new rule, but employers should be prepared to move forward if the court's decision is reversed. Look for upcoming issues of the resource for updates on the overtime rule. And remember, California employers still need to make sure exempt employees meet the salary test and the duties test under California law. Let's move on from new laws and regulations and talk about two recent cases that impact California employers. First, a decision out of the Ninth Circuit has created even more uncertainty for employers who use class action waivers in arbitration agreements. The case is Morris versus Ernst & Young. Ernst & Young employees were required to sign arbitration agreements as a condition of employment, and those agreements contained a class action waiver requiring employees to bring claims in arbitration solely on an individual basis, not a class basis. The court held that this class action waiver was unenforceable because it violated the National Labor Relations Act, because employees have the right to pursue work-related claims together in a class action. The problem with this decision is that right now it conflicts with the California Supreme Court, which has enforced class action waivers. This issue will likely remain in flux until the U.S. Supreme Court weighs in. For now, enforcement of arbitration agreements will largely depend on which court hears the case. Our final case, out of a California Court of Appeal, presents an interesting discussion of a disability-related issue. In Soria versus Univision Radio Los Angeles, Ms. Soria worked as an on-air personality for Univision Radio. She was diagnosed with a small tumor, but it was not cancerous, it did not cause any physical symptoms, and it did not affect her ability to do her job. However, she mentioned to her supervisors that she was thinking about potential surgery to have the tumor removed. She began missing work or arriving late to work for her radio show. Because of her excessive tardiness, Univision terminated her employment. Ms. Soria sued for disability discrimination and failure to accommodate, among other claims. Univision argued that she did not have an actual disability, since her tumor was not cancerous and she was able to work, and that she was fired for legitimate reasons, being late all the time. But remember that under California law, an employer can be liable if it treats an employee as having a disability or potential disability. The court found that Univision terminated her employment with knowledge that she was seeing a doctor, some of her tardiness may have been due to doctor's appointments, and potentially treated her as if she had a disability. What really got Univision in trouble is that Ms. Soria had received consistently favorable performance evaluations, and only when she disclosed her medical issue to her supervisors did her tardiness become an issue. This case is a reminder that regarding or perceiving an employee as having a disability can trigger obligations on the part of the employer, even if no disability is actually present. In addition, employers need to be careful when the timing of disciplinary action is close to the time that an employee discloses a medical issue. If the timing is problematic and the employer's reasons are inconsistent, it is unlikely that the employer will be successful and getting the case dismissed. Thank you for tuning in to this last update for 2016. San Diego SHRM is pleased to help keep you informed about issues that affect California employers. For more information on these and other legal topics, check out San Diego SHRM's newsletter, The Resource, at sdshrm.org. And we'll see you in 2017.